Hi friends, Tony DeWitt here, Missouri Appellate Attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. So the other day I did a video where I talked about the things that are going on in the Alec Baldwin case, and I talked about all of the briefing that's going on. One of the things that I think people don't understand is how it is possible for a lawyer to write something that is 100 pages long and call it a brief. Well, to be fair, I don't understand that either, because if you have something to say, you can say it in short declarative sentences, you can get it written and in the book in less than 10 pages. And if you can't do it in 10 pages, you don't understand the issue enough. And so that should be the guide when people do legal writing, but unfortunately, a lot of people don't follow those rules. They used to be able to get away with that, and in some cases and in some states you still do in a death penalty case. But for the most part, briefs have been severely limited by court rules. In Missouri, for example, we have limits on how long the briefs can be. And you can have limits in terms of the number of pages that you can file, or you have limits in the number of words that you can use. And so most of the lawyers that I know, that I work with, use the word limit because it usually gives you a little bit more to work with. And of course, Microsoft Word and all the other word processors count the words for you, so you know pretty much how things are going, how many words you've used, that sort of thing. So today what I thought I'd do is pull down a brief from the Missouri Supreme Court, which I've done, and we're going to take a look at this brief. I'll talk about some of the different things that are in the brief and how these briefs are put together. And I'll explain to you why appellate lawyers should do briefing and not trial lawyers. Many lawyers, when they write briefs, write like they were speaking in court. And so, it is possible to go through a very long period of time speaking and saying the same thing over and over and over again, talking about different subjects, and you go through, and you can easily speak 60 words in a minute and not say a darn thing as I just did. When you do that speaking, people just tune you out. But if what you're doing is arguing on behalf of a client and you're trying to get some relief for the client, you want your words to be effective. And the way to do that is not to use more words. The way to do that is to use less words. And we'll talk about that here in just a moment. Let's take a look at this brief. This is the brief of Philip Weeks versus St. Louis County. It's a brief in the Supreme Court of the state of Missouri. And in a brief in the Supreme Court, there are a couple of things that are required. This is called a cover page. It identifies it as the brief of the appellant. Over here, it tells you it was filed March 21st of 2024 by this fellow in St. Louis County. And then the next thing that's required is a table of contents. The judges want to be able to find your arguments, your authorities, all of that relatively quickly, and having a table of contents lets them do that. So you have a table of contents here, and you have the table of authorities cited here. The table of authorities is where you list all of the cases and statutes and constitutional provisions that support your argument. Then there's a statement of jurisdiction, a statement of facts, the points relied on, and the arguments. So then there's a conclusion, a certificate of compliance, and an appendix. Now this is the table of authorities. You can see that it has Barber versus Metro Police Department. That's 558 Southwest 3rd 70. Missouri Appellate Court, Eastern District, 2018. You can find it on page 17 of this brief. And Chasnoff, you can find on page 16. Geyer versus City of Kirkwood, again, 9, 12, 13. All of these cases are instrumental in this particular case. They have some bearing on the issues that are raised. And then these are the statutes and rules. The Constitution, Article 5, Section 3, Section 10, the Rules of Civil Procedure, Rule 8304, and then these statutes, including 590-650, which is the traffic stop statute, which is at issue in this case. So then we come on down and we get to the statement of jurisdiction. Ordinarily, when I have done these, I've called this the jurisdictional statement. When people phrase things sort of in the passive voice, when that's their normal way of speaking or writing, they tend to do things like this and use prepositions when they're not necessary. Far better to call this a jurisdictional statement than a statement of jurisdiction, because it's simpler. So he filed this lawsuit against Webster Groves in St. Louis County for failure to produce vehicle stop records according to the officer's department service number. And the Circuit Court of St. Louis County granted judgments to Webster Grove in December 28, 2022, and St. Louis County in February 2023 based upon their motions for summary judgment. And they denied Plaintiff Weeks' motion for summary judgment. The case was appealed to the Court of Appeals, Eastern District. The Court of Appeals reversed the grant of judgment to Webster Groves. And on November 14th, the Court of Appeals reversed the trial court's grant of judgment to Webster Groves and ordered it to produce vehicle stop records except for the stopping officer's DSN, and affirmed the judgment granted to St. Louis County, which held that it, too, did not have to produce the stopping officer's DSN. Plaintiff Weeks now appeals the decision of the Missouri Court of Appeals. No, he doesn't. I'll explain that in a second. Plaintiff Weeks' request for Webster Groves in St. Louis County to provide Plaintiff Weeks with the stopping officer's DSN when providing vehicle stop records. The Missouri Supreme Court accepted transfer of this case on March 5th and pursuant to the rules of civil procedure. So what happened is, after he lost at the Court of Appeals, he filed an application to transfer. He is not appealing the decision of the Missouri Court of Appeals. How do we know that? We know that because the Missouri Court of Appeals opinion is no longer in existence. When the Missouri Supreme Court takes transfer of a Court of Appeals case, the Missouri Court of Appeals decision goes away. It's no longer relevant or precedential unless, in deciding this case, the Supreme Court says we reinstate the opinion of the Eastern District. That would be the only time that would happen. But this is a common error made by people who don't do a lot of appeals, and particularly who don't appeal to the Supreme Court. Statement of facts. Again, just as easy to say factual statement. Now, this is some less than optimal legal writing. Plaintiff Philip Weeks, plaintiff, brought this suit to enforce his Sunshine Law request to obtain records of all individual traffic stops by police officers employed by St. Louis County and Webster Groves. All right, that's a 3-line sentence. It's a little bit long. I always tell people, if when you read something out loud, you have to take a breath, your sentence is just too long. First of all, if we say Plaintiff Philip Weeks, plaintiff, we don't need plaintiff. But if we say Philip Weeks, plaintiff, that's okay. So what I would do, I would line through plaintiff. Philip Weeks brought suit. How about sued to enforce his Sunshine Law? And I would just skip this because we're not citing legal authority here. We're saying the facts. And you don't really need to have that citation in there. Requests to obtain records of all traffic stops by St. Louis County and Webster Groves police officers. And so, since we know that they're employed by one of these two agents, we don't need to put employed by. Just say they're police officers. Now, this one here is a really long sentence. This includes all information, data collected as required under RSMO 59650, the Vehicle Stops Acts, entered by an officer about a traffic stop, including the officer's department service number, his identifying number given to him by the officer's police department. Man, I almost got hypoxic doing that. Way too long of a sentence. This includes all data required by, in other words, required by here, under required by RSMO 59650, period. This information is entered by the officer and includes his department service number. We don't need to put in here how he got his department service number because that's not relevant to what you're looking for. You're just looking for this number right here. All information about each individual traffic stop. Okay, how about information about each traffic stop? Why would you need to modify it with individual? I don't understand that. Is sent electronically by the officers or the officer's department to the Regional Justice Information Services Commission for it to maintain on behalf of St. Louis County and Webster Groves. Again, because you have a page limit or a word limit, and in this case it's a word limit, you want to reduce the number of words that you use. So after you write something like this, as a lawyer, what you're supposed to do is go back and edit it mercilessly and drill it down to only that which is important and which is necessary. And then it goes into things about what Regis is, what it maintains, what it produces, how it does the records. And then down here we get to the points relied on. Now, points relied on are unique to Missouri law, and they are in a particular framework. It has to identify the order or judgment that you're appealing. In this case, the trial court erred in granting judgment to Webster Groves in St. Louis County, holding that they did not have to identify the stopping officer when reporting vehicle stops, which was affirmed by the Court of Appeals because, well, let's take a look at the rule here and see what we're supposed to be reading. Here's what the rule says a point relied on should look like. Identify the trial court ruling or action the appellant challenges. State concisely the legal reasons for the appellant's claim of reversible error and explain in summary fashion why, in the context of the case, those legal reasons support the claim of reversible error. The point shall be substantially in the following form. The trial court erred in, identify the challenged ruling, because, state the legal reasons, and in that, explain why the legal reasons support the claim of reversible error. Now that's clearly not what we have here. This is very long and it doesn't follow the format in the manner that it's supposed to. Now I took the point relied on that the appellant used here and I edited it to be much more compliant and much more succinct as it applies in this particular case. Let's take a look. The trial court erred in granting summary judgment to defendants, stating they did not have to identify the stopping officer's DSN because RSMO 61010 governs the production of public records created as required by RSMO 590.650, in that the Sunshine Law provides governmental records shall be open to the public unless otherwise provided by law, and the Vehicle Stops Act does not restrict reporting any information recorded about vehicle stops. Again, indicative of somebody who doesn't do a lot of appeals. And then after the points relied on, you get into arguments. Standard of review applicable to both points relied upon. And then we get into the points relied on. The majority of the Court of Appeals maintains the plaintiff requested vehicle stop information that was kept pursuant, and the plaintiff was limited to obtaining only the information that was required to be reported to the Missouri Attorney General. So he goes on and builds out his argument from there. And then at the end of the brief, he comes down here and he says, for all the reasons stated above, given the importance of determining the officer's identification, this court should reverse the Court of Appeals and hold that the stopping officer's DSN should be included in vehicle stop records provided to plaintiff. So that's what a brief looks like. And writing a brief is something that requires a fairly long time. It usually takes me at least a day for every point that it relied on. And that means that I have to do legal research on the point. I have to gather up the cases. I have to figure out which cases are the best cases. I have to structure my argument, and then I start writing. It can be a very long and time-consuming process, but if you do it right, you usually wind up with a good result. This has sort of been a peek behind the curtain, a little bit of inside baseball, so to speak, about briefs and how lawyers do their job. I hope you found this interesting. If this is boring or you don't like it, please let me know in the comments, because I could use that to improve some of the other things that I discuss on the channel. Thank you so much for watching. If you have any questions or comments, drop them down there too. And then come on back down here tomorrow after you do something nice for somebody, and we'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.